If you've never been to a JazzHR workshop before, welcome. I'm excited to see new faces, and if you've been to one of our previous sessions, I do see a lot of familiar names, and you've probably heard my voice a million times, so I'm happy to see some familiar names on here. It's hard for me not to say faces. I obviously don't see your face, but I do see a lot of names that I know. My name is Lila Roselle, and I've been in a few roles here at JazzHR, but I'm now in the marketing team, bringing you all kinds of workshops on different HR topics. So I did want to do just a really brief poll before we kind of jump into any of the housekeeping and the introductions here, just to kind of see where we're all at in the state of the medical marijuana kind of landscape that's going on right now. So if anyone just mind filling this out, I'll give you a couple minutes to just kind of plug in your responses here. I know we have a lot of folks on the actual workshop today, so could take a little bit for these to come in, but while everybody's still here and listening and paying full attention, nobody's kind of switched on their phone. Let's see what kind of results we can get. And I know this is, if you don't necessarily have it now, it might come down the road, but we're just kind of curious, who right now does have legal medical marijuana or in the process of it or just voted on it in the recent election or has fully legal marijuana, all kinds. So I'm going to close up in just a couple seconds here, waiting for our last few people to kind of Google and wonder if they do have it. All right. I'm going to close the poll. All right, so overwhelmingly, 72% of you, do actually have legal marijuana or medical marijuana. So pretty interesting. That's probably why you're here today. But for those of you who are in the no bucket, definitely something that's going to be helpful for you, either as it comes into your state or as it moves kind of across, or if you move different locations. So very interesting. Good to know. So I'm going to hop into housekeeping. Here we will be recording the workshop, and audio is streaming through your computer today. There's no dial-in here. It's just audio streaming through the computer. So if you are having issues and it's requesting a dial-in, just try and log out and log back in, and you should be able to just have the audio streaming through your computer. So trying the test options and things should work fine. And then there is a chat box on the left-hand side if you do have any questions. And we will have a Q&A at the end, so you can feel free to ask questions all throughout the presentation. So definitely ask if something comes up in your head. But we will get to that question at the end, and if we don't, we try and follow up with as many people as possible. So definitely ask away, even if we can't get to it. Definitely try and follow up with you. And you'll all receive a copy of the slides and the recording. So if you do have to step out or anything, you do get the recording. But the ability to ask questions is the most exciting part, and hear your answers live on air. So without further ado, I'm going to introduce our speakers for today. So we're joined by Jim Southworth of Dickey McCamey. And prior to becoming an attorney, Jim was a human resource manager for a hospital in Indiana. So this background has given him an understanding of the issues that companies face when dealing with employees, and enables him to provide advice that not only passes legal muster, but is also grounded in the reality of the workplace. And on the HR side of things, I'm joined by Cheryl Bean. She's the president of Compass Resources, and she's an experienced HR professional who's lending her expertise to all things HR and business related on the workshop today. So from attracting and hiring and retaining talent. So she's kind of the business and HR expert here today. And her diverse background and knowledge of a bunch of different size businesses will help us kind of learn how to navigate some of the tricky items in the call today. So we're super happy to have you guys, and I will stop chatting and we'll get to them who has the actual good information. So welcome.
Thanks, Lila. I appreciate it, and welcome to everybody who's joining us for this conference today. We did get an early preview of who you were and where you were from, and was interested to see that there's several Canadians joining our call today. I'm guessing that's because you have businesses here in the U.S. as well, or operations here in the U.S. Welcome to the call. We hope to be able to provide a good overview for everyone. And to the Canadian folks, I always say thank you for hockey, by the way. But today is April 20th, so there's a lot of marijuana activity that happens today, a lot of information, and CBS News did a poll that they issued the results of today that said that 61% of Americans think that marijuana should be legalized. 71% believe that the federal government should not interfere with states' rights as it relates to medical marijuana, or as it relates to marijuana, and 88% of Americans favor medical marijuana. So those numbers are pretty shocking, I think.
No, excellent. I think that's a great point. And I just want to touch real quickly on something very similar. Jim brought up that today is April 20th, 420, and I'm sure many of you are aware that that's a relatively important date in American culture when it comes to this whole issue of marijuana. It's been over 30 years that that term was first coined back in 1971 as a result of a treasure hunt for a cannabis farm that never materialized, but that's how it all got started, and that was further popularized by a movie called High Times, as well as The Grateful Dead. And also today, I believe, Colorado, if you're represented, I think you are, is the first drive-through for legalized marijuana. I think it's called the Tumbleweed Express. So we'll be curious to see how that evolves as this whole process keeps growing across the United States. There we go. So as Jim was mentioning, and you have the screen in front of you as far as the status, and as we've just mentioned, this is obviously evolving, growing. It's not going away. It's something that we all need to try to manage and deal with in the best way possible. And we also understand your situation. We've been in your shoes, and we appreciate some of the frustrations that you may be having and related to how do you deal with this on a daily basis? How do you manage this between the federal and your state laws and even local laws? And then how, of course, do you manage this with your employees? So it has to do with all these pieces, and our goal here today is to touch base on all of these, give you really some key points, because obviously this is a very complicated topic, but we'll do our best to give you some things that you could use right away in your organization.
And just to pick up on the slide that you are now looking at, obviously we've been talking about the trend towards legalization continues, and it does. You see the map there that shows both where it's legal recreationally and as medical marijuana, and many of the other states that are currently white are considering laws and may change within the next year. One of the things I wanted to point out is, as most of you know, and one of the things that makes a presentation like today difficult is that we're talking to multiple states, and there is this issue of states' rights to control marijuana usage versus the federal government, under which, under the Controlled Substances Act of 1970, marijuana is still a Schedule II substance, therefore illegal from federal law perspective. That creates a dicey situation. And just as a kind of a 30,000-foot perspective issue on this, under President Obama, when much of the marijuana laws started to take root throughout the United States, the theme of the Obama administration was basically we have bigger fish to fry, and they basically looked the other way when it came to enforcement of marijuana laws under the Controlled Substances Act. Donald Trump, during his candidacy, seemed to indicate he would continue that trend, certainly favored states' rights and continues to favor state rights on many issues. However, when Jeffrey Sessions was confirmed as the Attorney General, one of the first things that he said was that he was going to start enforcement of federal marijuana laws. He received significant pushback from senators and other congressmen from states where it was currently legalized or in the process of being legalized, and he backed off a bit. At this point, it's a bit unclear where this administration is going to land as it relates to marijuana, but I think that in general, given the the movement in the country towards legalization, at least of medical marijuana, I suspect that there's likely not going to be a lot of push from the federal government to go after those laws. And in fact, would not be difficult for the federal law to change. And I don't want to monopolize. I'm going to turn this back over to Cheryl in just a minute, but it's interesting. Many people don't know this, but the reason marijuana is a Schedule II drug is prior to 1970, it was legal. There was not a federal law against marijuana. But when the Controlled Substances Act was written, the legislators who were writing the law put marijuana on the list with the other Schedule II drugs, which are heroin and opiates and hard drugs. They set marijuana there because they didn't know where it should go. They wanted to get input from physicians and pharmacologists, and that never really happened, and the law was passed, and it just kind of stayed where it was put. Thus, marijuana is an illegal drug per federal law. That creates a lot of challenges, and we're going to be talking about some of those challenges as we go through the presentation today.
And one little add in relation to some of our government agencies, the FDA has not recognized or approved botanical marijuana as medicine. Now, there are some approvals there in relation to some synthetic versions of it, but that also is one more piece. As Jim mentioned, we're talking about federal versus state with medical marijuana that just creates a little more confusion for us as employers and the best way to deal with this. So as he mentioned, we want to get in a little bit more into the nitty-gritty as far as what you can do in relation to that.
Yeah, as you see on this slide in front of you, state laws and marijuana, this is part of what makes this a difficult and challenging issue. You've got a kind of different baskets of marijuana laws. You've got medical marijuana statutes. For instance, we're coming to you from the state of Pennsylvania. And in Pennsylvania, we just passed a law in 2016 that allows medical marijuana. We don't have our processes in place yet, but the state has now drafted a statute that allows medical marijuana in our state. However, both Philadelphia and Pittsburgh, the two biggest cities in our state, decriminalized marijuana in the last several years. So although it's now legal statewide for medical purposes, the two cities are not enforcing criminal statutes against marijuana users, and then we still have the federal law. So you have other states that prohibit discrimination on the basis of medical marijuana registration card holders. You have some states that don't. And you have some that prohibit the use in the workplace or on employer premises, and some that don't even address that issue. So there's a wide range of laws out there, and it really depends on the jurisdiction in which you reside. And all are under the umbrella of a federal law that still says it's illegal.
So if I'm the employer, and that's kind of the role that I'm taking here, I work a lot with Jim as our employment attorney, but if I take on your role as an employer, when I look at this with the state laws and marijuana, the very first thing we recommend is touching base with your attorney, with what's going on in your state, and making sure you're very clear on what that information is and where you stand from a legal perspective. So your federal laws, your state laws, your local laws, as well as any laws, of course, that are going to apply to if you're near another state. We've had issues related to employees crossing into a state that does have legal recreational use and or medical marijuana, and what does that do for you as an employer? So obviously you've got to have as many of the facts as possible in your bag of information so that as we go forward, you can handle this in the best way possible to protect yourself as well as your employees while on the job. So let's move on to another slide here. There we go. So when we look at all the different workplace issues to consider, when you look at this slide, this is really no different than other issues that we have had to deal with over the years in regards to any type of drug or alcohol abuse or any type of substance abuse in our organization. So in a lot of ways, we're going to treat it sort of similarly, and we'll dive into that a little bit more specifically. As you see, it all comes back down to the number one reason as to how we want to act and react to this is workplace safety. But all of these pieces obviously tie into it when we're talking about how to deal with any type of abuse or medical marijuana now in the workplace. So we're going to break these down a little bit, and as we go through, address some of these more critical items. But on all of these, again, because we really only have a short time with you, please be sure to check what's going on in your particular state, because different court cases have come up with different answers depending on what's going on in your state.
Yeah, for instance, that one at the top, unemployment insurance. So one of the questions that has come up in quite a few jurisdictions is, okay, maybe a person's allowed medical marijuana in the workplace, in the state, but the workplace still has a drug-free zone or a no tolerance policy, and so they may terminate a person for using medical marijuana. And what ends up happening is that person then goes and files for unemployment compensation insurance. And the question is, should they be able to get unemployment compensation? In the past, Arizona has said, for instance, no. They still broke federal law, so they shouldn't be able to be entitled to unemployment insurance. But there's a fairly famous, relatively recent case in Michigan that says, no, they should be entitled to unemployment compensation. So each one of these areas is something you really need to think through. It really is, it's an issue that's going to be far more pervasive, I think, than most employers are currently thinking. They think if I just change my drug testing policy, I'm okay. Well, it bleeds into a lot of other things. Criminal background checks is another thing that it's going to affect. And certainly it's going to affect drug testing, which we'll talk about a little bit in a few minutes.
One more little thing on the criminal background checks, or maybe not a little thing. Also, too, what is your philosophy? What is the conditions that you operate under? If you're dealing with federal contracts, if you're under DOT regulations, these criminal background checks, again, depending on the state, in some cases, possession of marijuana, medical marijuana, could be considered a misdemeanor, could be considered a felony. So there's a variable there too. It's really frustrating as an employer for how are we going to deal with this in the best way possible. As we said, we're going to keep coming back to workplace safety to give us the leg that we need to stand on to make the right decisions.
And two, as to the government contractor issues, that's been made fairly clear that administrative orders have indicated that, government contractors are still going to have to be drug-free. DOT has said, anybody doing over-the-road interstate travel on trucks and thus subject to DOT regulations are also going to have to continue to be drug-free. So there are some black and white areas of this law, not many, but that's one. If you're a federal contractor or if you come under DOT regulations, you're going to have to be drug-free. So whether your state has or does not have medical marijuana or recreational marijuana is going to be irrelevant. You still need to follow federal law as it relates to those issues.
All right, let's move on a little bit. Let's talk a little more specifically, kind of big picture first, and then we're going to keep drilling down into, so what are you supposed to do? You're an employer, you're out there, how am I going to handle this? Well, obviously, we want to take all of this very seriously. I mean, there's so many different ways to look at this. I mean, there is a perception, and everybody's got an opinion on this, on whether medical marijuana is a good thing or a bad thing. Obviously, it is being used successfully for a lot of people with a lot of different health issues. So there's certainly a positive aspect there, but there's a negative aspect as far as abuse and what that does to people while on the job, workplace safety. So what we're saying is, number one, obviously, is to take this very seriously, to really dig into what it is that's going to work for you as your organization. And here we talk about this idea of taking any accommodation seriously. Now, the thing is, and we'll talk more about the Americans with Disabilities Act, but basically, under the ADA, again, that's federal law, you're not required to accommodate for medical marijuana. Now, not to say that hasn't been tested, and so it's kind of waivers depending on certain cases that we look at, that as far as how that might be interpreted or translated into the day-to-day workforce. But as of this point in time, as far as a reasonable accommodation for someone using medical marijuana in the job, it's not an accommodation under the ADA. But again, we've got to keep an eye on things because that could change. Bottom line, just pay attention to what's going on as much as possible.
Yeah, that actually is a really interesting issue, the accommodation issue. And since we brought it up, I want to talk a little bit about it. So here in Pennsylvania, for instance, we just passed this law in 2016. It says that we now have medical marijuana in our Commonwealth. Well, our law says that you cannot terminate an employee or otherwise have a negative employment action towards that employee solely on the basis of their use of medical marijuana. We're one of only 4 states that have those kind of protections. Us and Arizona, Delaware, and Minnesota are to this date the only states that have some kind of employment protection written into their statute. Well, my thought was, okay, so if that's in there, how are we as employers going to handle the situation when an employee asks for an accommodation? Because it's true, since it's illegal under federal statutes, we have no obligation to accommodate them under the ADA. But most states have state statutes that mirror the federal statute. For instance, we do in Pennsylvania. And that Pennsylvania Human Relations Act, it's called, and that act basically mirrors the ADA. So my thought was, well, if I'm a plaintiff's attorney in Pennsylvania and an employee's been terminated and they come to me, I'm going to rely on that reasonable accommodation through the state law. I thought that was probably, a pretty tight argument until I looked at a case from Oregon that exact argument was made. And the court said, well, here in Oregon, it doesn't matter whether or not they should have accommodated under the state law. They still had, they're still in the United States of America, and it's still illegal under federal law. Therefore, the employer had no duty to accommodate. That is not the outcome I expected, but it's still good law as of right now. Now that's a state law, so it's only good in Oregon. But typically, when there's a trend like this, states look to one another for guidance. Again, I know we sound like a broken record here, but you really are going to have to pay attention to what's going on in your state, and you're going to have to rely on legal counsel to do that.
The next piece we're talking about, don't stigmatize medical marijuana as being something so unique. It is, but in the grand scheme of things, we're going to treat it very much as we would with any prescription drug that someone might be taking, for example, Percocet or oxycodone or something. And I know how I react to drugs like that when I've had to take them based after illnesses or whatever I had, and it's not pretty. So we want to take that same approach to any type of drug that someone is recommended or prescribed, to making sure that they're performing as best possible on the job. So we're going to handle it the same way, put it in that same bucket, that this is our requirement and this is what has to happen while we're on the job. So we really don't want to, in that aspect, separate it out as far as an individual statement. We're treating anything that could impact our behavior on the job as our opportunity to act and react to a situation that could lead to a safety issue for our organization, for any employee or any visitor to our site. So what? Number 3, could you move us ahead there, Lila? There we go. So this ties right into what I just mentioned as far as we don't have any right to be impaired at work. That's the thing we need to focus on. So when we're looking at this, is making sure that everyone understands what their duties are, what their essential functions are, and what they're required to perform on the job, and that they can perform them in a way that meets the expectations of the organization. We're talking about communication, making sure that everybody understands what those expectations are and what's going to happen if those expectations are not met. And I know probably all of us, most of us for sure, do what we can to make sure we communicate, but it's one of those things where communication, you really can never do that enough to make sure that everybody's on the same page and understanding what our expectations are around those lines.
Yeah, that's a good point, Cheryl. The thing that I think I try to draw my clients back to, I get calls all the time. I'm thinking about terminating this employee. This is the set of facts that are making me think about terminating the employee? Do you think I'm safe terminating the employee? So forth and so on. And what I often find myself counseling clients is you always have to go back to make your decisions based on performance-based decisions. Is the person performing what they're expected to perform in the job they're doing? Are they doing the essential functions of their job? That's what keeps you safe. That always keeps you safe. It doesn't matter what jurisdiction you're in, federal, state, otherwise. If your decisions are purely based on performance, you as an employer have a right to certain expectations of performance. So that's what you want to focus on. And if a person's impaired at work and that impairment is keeping them from performing their job at the standard that you expect, then that should guide your decision, and you have every right to make a decision on that basis.
So Lila has here number 4, then identify those safety-sensitive roles. Kind of going back to those essential functions that I mentioned earlier, a lot of times when we're looking at your job descriptions, we want to make sure that whatever's tied into those duties and expectations, as well as workplace issues, working conditions, how does that tie into safety-sensitive positions? Now, in the U.S., I know we have our Canadian friends here too, the Department of Transportation pretty much lays that out in black and white for us as far as the core safety-sensitive roles are those in aviation, trucking, railroad, mass transit, pipelines, and the Coast Guard. But you may have additional functions at your organization that you also consider to be very critical positions for what they're doing. I mean, I think of people working on electrical lines. I think of people working underground. I think of people working in mines. I mean, there's a lot of things to consider. So what we're suggesting is take a look at those and make sure that we understand what the impact is in our organization, and that's going to give us some information too as to how to write those policies to make sure, again, we're staying safe, keeping our employees safe, keeping our organization safe.
Yeah, for instance, our Pennsylvania law specifically states 3 professions that a person using medical marijuana cannot participate in. The first is underground mining, because we have a fair amount of underground mining in Pennsylvania. The second is working around chemicals. It doesn't really define what that means. It just says working around chemicals. And then working with high voltage electricity. Now, what I find interesting about all that is, I mean, certainly that would be true of those professions, but I would add so many more to the list. For instance, my background is healthcare. I certainly think, if you're a hospital or a healthcare provider of some sort, any patient care area almost is safety sensitive. So you're really going to have to think that through on your own, and it's not always going to be spelled out for you in the statutes. Statutes are going to be pretty bald, pretty simple, and you're going to have to flesh out for your workplace what are the safety sensitive roles that you're not going to tolerate any use at all in those roles.
And going back to your job description, that's going to help you out quite a bit, as Jim mentioned. If all these things that we're talking about, and now you go back and you look at those job descriptions, you look at those essential functions, you look at the working conditions, if any of those things tie into it at all, again, or anything that you feel could have a more serious impact on the general public, your employees, visitors, all that type of thing, that's going to give you some information, almost like you want to make a list that here's all my positions that are considered safety sensitive, here's those that I would consider not, and you may have some that are kind of in between, but it's doing the analysis up front to make sure that you have all that information. Information, knowledge is all critical to help you in making the right decision. So that's definitely a next step for you in taking a look at these things. What else can we do, Lila? Offer of employment. Yes. So offer letters are important and are an excellent means of communicating right off the bat what your expectations are for anyone who wants to join your organization. Not only the culture of your organization, but as far as what the expectations are in relation to this issue, then as far as our company policies, their requirement to review and sign off on your employee handbook, your employee manual, and any types of pre-employment drug testing and or drug procedures that might be applicable to us.
Yeah, I think I know what probably most of the listeners to this call are thinking about attorneys. You think that we encourage legislators to draft laws to make it impossible for you to navigate the employment world so that anything you do is going to lead to litigation. I can't say that happens. I can't say it doesn't happen. All I'll say is it does appear that this is exactly the situation, for instance, you're in here. We're going to talk a little bit more about drug testing later in the call, but an offer letter that lays out your drug testing policy, for instance, in the state of Pennsylvania, where you can't have a negative employment action solely on the basis of use of medical marijuana, if they either make known to you that they're users of medical marijuana, or if you test them post-offer pre-employment and the test is hot and you say, well, I'm not going to hire you, it seems to set you up right off the bat for a failure to hire claim. Or if you do hire them anyway and then a bad thing happens, it seems to set you up for a negligent hiring claim. And my answer to that is yes. It does. Both those things present risks to you, and that's why a drug testing policy. I can't tell you how many times I've worked with clients that took a drug testing policy and pulled it off the internet and just put it into their handbook, and they haven't really thought through the steps of that policy, what it means in terms of how it opens them to liabilities for whatever they do with the employee or for what they don't do to the employee. And that's a critical piece. You really need to think through your drug testing policy, particularly now in light of the fact that there's this whole new world of tests that are going to be potentially hot, and what are you going to do with those, and what decisions are you going to make? We've talked about things like, so what happens if you have an employee that goes out of state to a state like Colorado where recreational is legal and participates legally in, they smoke pot while they're there in Colorado. They don't bring any back. They just come back to their home state, but they get randomly tested the next day and come up hot. They didn't do anything illegal. But that so you're gonna have a decision to make. How are you gonna handle that? And if you've been in HR very long, what makes or breaks the HR world in litigation is how consistent are you? Do you do the same thing every time to each person in that circumstance? So I can't emphasize enough how important it is that you really think through your drug testing policies. And we'll talk a little bit more about that later. I just wanted to bring that up.
No, good, excellent point. Communicating company expectations, it's kind of interesting. We all do this, and guilty myself. We feel that we communicate enough. However, a lot of times when we've gone in and talked to employees and polled employees and done different types of assessments, we say, do you get enough communication? And we talk to the department that's issuing the communications. They say, yes, we do X, Y, Z. We do all this, and they do. Yet when we go back sometimes and talk to the employees themselves, it's like, no, don't remember that one, didn't communicate it. So you can really not over-communicate is our point here in making sure that people understand, whether it's job applicants, employees, anyone who comes in contact with your organization, that they understand your position when it comes to dealing with any type of drugs on your organization, on your property, and how that's going to be handled. Which is why we go back to making sure with an employee manual that you have a sign-off sheet, just to make sure that that person recognizes the importance of our policy. Some people feel that's a little bit kind of reading over my shoulder kind of a thing and watching me micromanaging. It's not. It's really just to make sure that everyone's on the same page as much as possible. And obviously giving people the opportunity to ask questions too, which leads us into our next slide on, what's it on? There we go, training employees and supervisors. Both Jim and I, Jim and Compass, we do a lot of training and development on making sure that employees, supervisors are fully aware of what they need to look for in regards to people, situations where there is an unfit for work perception, actual, whatever, to make sure they understand what needs to be done when we see someone like that. One of our biggest concerns is when employees and supervisors are not aware of what different behaviors could be considered improper behaviors or inappropriate behaviors or not in line with being able to perform the duties safely. This is where the training can come in and can help you quite a bit. It certainly doesn't make you a counselor or a physician by any means and by going through this training, but it does make you very much more aware of what you can and can't do. There was a situation not too long ago with a court case in which a supervisor felt he was doing the right thing, saw someone that they felt was under the influence and said that he felt that the person was stoned, whatever, using words such as that. I think most of us know now we should never do that, right? We want to focus on what we see, the actual behaviors of a person, and then take action based on that. But I know Jim's come up across that quite a bit in his experience as well.
Yeah, it's the thing that employers need to understand, and many do, but oftentimes the way they learn this lesson is the hard way, which is through litigation, is that their managers are, from a legal perspective, your managers and supervisors are agents of your business. If they're agents of your business or company, that means when they talk or when they do things, their actions and their words are the company's actions and words. They're your agent. They're acting on your behalf. So it's very important that you give those people who have such really powerful, a powerful influence over your organization and the liability that you face from a legal perspective, to give them the tools they need so that they know what to do and what's appropriate. One of the things that they need to know is one of the things we've talked about is this is all about performance, and it's about, is the person impaired on the job? Well, the only way you're going to know that is if you've had some training to understand what to look for, and there are things that you look for, pupil dilation, is the person sweating, is their speech slurred, are their thoughts coherent? There's a specific set of characteristics and things that you look for in an individual to determine if they're impaired. If you don't give that information to your managers, then they're just kind of going on their gut. And if they're going on their gut, they may make mistakes. And if they make mistakes, the liability is going to be on the company. So it's so important to provide those frontline managers, the people that actually deal with your employees, the training they need to be able to spot impairment and to be able to know what to do if they spot impairment and to take the right steps.
Very good. So number 8 kind of takes us back to the foundation of all of this. We've been talking about making sure you understand what your state and federal laws are. We're going to take a little bit of deeper dive in that in a few minutes here. But bottom line is, what's your policy say? This is your mouthpiece. This is what explains your position on dealing with any type of drugs or alcohol, which alcohol is also a drug, within your organization. So making sure that it's very clear, Jim brought up earlier about being careful about taking something from the internet and plugging it into your manual without being sure that it's in sync with your expectations and how you're going to respond, react, and manage any situations along these lines. So how are you going to deal with prescription and non-prescription medications? Again, like I mentioned before, I swear sometimes I can just take a couple Tylenol and it makes me feel a little weird. So it's not necessarily just prescription drugs. It can be anything that impacts a person and how they respond on the job and how that impacts their ability to do their job. What's going to happen when you're talking about marijuana, when you're talking about recreational marijuana, depending on what's going on in your state, the use of medical marijuana, how that's going to apply, off the job, on the job, at work events, all the pieces we've been talking about, how it impacts job performance, making sure that employees understand what the expectations are, putting it in black and white in your policy. People can't come to work. If they're under the influence, they have to be able to perform their job in the manner expected based on their essential functions, their job description. How do we feel about the use of drugs or alcohol off company property or at company events? Again, that's going to have an impact. That's a tough one sometimes for people.
Yeah, I have to admit, when we don't have recreational marijuana in our state, so when Cheryl and I were putting this presentation together, we talked through these bullet points on number 8 and got to that one, company position on use of drugs off of company property and or company events. A lot of my clients, I've drafted for them policies related to alcohol use at company events. That's something we're familiar with. I just never imagined a company event where people would be sitting around partaking in marijuana. But it is, if recreational is legal in your state and you're going to allow that, and maybe you will, then again, you should have a policy that addresses it, and you should really think that issue through. And just like we would with alcohol policies and stuff, you might want to have Ubers handy and so forth. You want to think through not just the policy, but the implementation of the policy and what does it actually mean in the real world. If we're going to let people do that, then we need to have a safe place for them to stay or whatever, and we need to provide transportation for them safely. Or you have to think through each step of your policy.
Going back to your state, I mean, as we go through and look at all the different states, we were kind of interesting to find how many states allow you with medical marijuana or certainly with recreational use, a certain number of plants that you're allowed to grow in your own home environment. I was kind of interested to find that Alaska allows up to 12. And that's, I think, the highest of all the states. Most of them are around 3 or 6 if it's permitted in your state. So it's such a variable that's out there as far as the perception of recreational use for marijuana and certainly medical marijuana. So you've got to be clear that everybody is on the same page as far as what that's going to look like in your organization. Let your policy lead the way. And then what are you going to do about testing? What are we going to do as a consequence when someone does test positive for medical marijuana? Here we go. Let's talk about that a little bit.
Yeah. So I stole this chart from California group dedicated to reforming California marijuana laws. What you'll find if you look for a lot of this information is most of the good information on the internet, where it's actually cited information and it's well documented, comes from groups that are pressing for legalization. But nonetheless, here's one of the things you're going to face as an employer. So we have pre-employment drug tests, we have incident testing, we have reasonable suspicion testing. Marijuana is so much different than alcohol because the testing is different. You can't take a breathalyzer and find out if a person's impaired by marijuana. In truth, most state laws, and Pennsylvania is like this, identifies intoxication or impairment by marijuana by how much of it is in your bloodstream. Well, if that's going to be the standard, then that means you're going to have to blood test people. That is, that's a very invasive test, and most employers don't do blood testing. It's expensive. It's not immediate. You usually have to send the people away. Somehow you got to get them there to have that test taken. You have to do it quickly because it leaves their blood system very rapidly. So this is another aspect of marijuana that will cause fits to employers. What this provides for you, this chart, the top box is a single use of marijuana. This person has only used it once. You're gonna be able to find that in their urine for 1 to 7 days. So urine may be a good test for it. I found some home health tests you can buy online that are urine tests, and they swear that it'll detect as quickly as 2 hours from when a person first smoked marijuana or somehow got marijuana in their system. It will test as quickly as 2 hours from that, and it will last up to 6 days. So, and that's for a first-time user. Blood, 12 to 24 hours. Hair, it's doubtful you're going to find it if they've only used it once. Saliva, there is no good test. There's not a saliva test that's worked yet for marijuana. If they're a regular user, if they're a medical marijuana user and they're using it regularly, it could show up in the urine for up to 100 days. It'll stay in their system that long. Blood, 2 to 7 days. Hair, months. So the reason I brought this up is this really changes drug testing policies. And maybe if you're in a state where it's legal, maybe you just want to drop marijuana off the drug test list. That's a possibility. Or maybe you don't. Maybe you want to stay drug-free and just continue to enforce. Those are decisions that you can make and are going to be lawful for you to make, but you need to be consistent. You need to make the decisions for a discernible reason, to be able to articulate what the reason your decisions are based upon. And this is why I say you really are going to need legal counsel when you draft these policies.
Here's another piece related to the drug testing, too, when we're talking about marijuana. So marijuana has two main molecules that often will show up during testing. We've all heard of THC, and there's another one called CBD. So the THC, tetrahydrocannabinol, if I'm saying it correctly, I'm not very good at some of these names, and the CBD, cannabidiol, which is the other main ingredient. I mentioned way in the beginning that some of these are also synthetic versions, and also when it comes to THC, we all metabolize it so differently. And it may impact one person completely differently than another, and of course that's not necessarily that far different from any other type of drug, but it does complicate things with THC and doing the drug testing, because it could be if someone had it in their system with this regular use from over 100 days ago, but it's not impacting their day-to-day ability to perform their job now because it's not having that connection to their system. So that creates more complications for us when it comes to testing. But at this point in time, testing, of course, is legal and recommended in many cases, depending on your policy and how you move forward on that. It's still a slippery slope, though, on how this is going to be played out as we move forward and how it's going to impact your organization.
Yeah, and Lila, if we can switch to the next slide. The one thing we've already talked about the ADA, but I wanted to bring up something that you should be aware of as employers. So what you want to be careful about is don't think just because the person is, because there's law in your state that has said you can terminate a person for use of cannabis even if they have, if it's medical marijuana. For instance, that Oregon state. If I was talking to an employer in Oregon, I would still urge caution under the ADA. Here's why. If they're using medical cannabis, they're using it for some underlying medical condition. So they could easily flip that on you and say, okay, well, they didn't terminate me because I'm using medical cannabis. They terminated me because I'm an epileptic and I'm using medical cannabis to treat my epilepsy. And then they have an ADA claim. So that's another part of this that you have to look at and process through in your termination decisions or no hire decisions.
And what's been interesting when you look at a lot of these court cases and look at some of the summaries in relation to it, as Jim mentioned, right now it doesn't necessarily protect someone as a medical marijuana user. However, over and over again, we're hearing this same message, and hopefully, or perhaps you've heard the same thing, that it could. There could be a situation where it might be perceived and give someone protection for using medical marijuana if it's being used to treat a specific ADA disability. So it's not black and white. It's something we're all just going to have to work through as time moves on here.
Yeah, and the same would be true under the FMLA. It's not going to be the use of marijuana that entitles them to FMLA. It's going to be the underlying condition for which they're taking the medical marijuana. So, you can't quickly dismiss any of these federal statutes, even though it's illegal under federal law. Those statutes may still apply because there's an underlying health condition that they apply to.
And here's what's interesting with this FMLA too. It's obviously in there to try to help people. Oh, I'm sorry, we moved ahead a little bit. Can I make one more comment on the FMLA, because I found that I thought it was really interesting, is of course it focuses on the serious medical condition, but the use of medical marijuana during FMLA time off is in most cases considered irrelevant. However, it could be tied in. If a doctor directs someone to take medical marijuana as a treatment and is allowing that medical marijuana, it could be then tied into that person has to be off for FMLA in order to be able to use the medical marijuana in order to treat their severe medical condition. This is like a big chessboard. And then the thing is, if that employer has a zero tolerance policy, that employee comes back, they're on FMLA, they're using medical marijuana, we have a zero tolerance policy, and we fire them because they were drug tested and they have it in their system. There's a potential that could be a lawsuit if the jury thinks that the termination was due
retaliation.
Retaliation. So it's confusing.
And that is, I'll tell you just as a practitioner, in the last 3 years, most FMLA cases I see are retaliation cases. They're not, we used to see, you were keeping me from using FMLA or what. Those were the cases that used to be more common. Now retaliation is by far more common.
And what do we have? We have the Drug-Free Workplace Act. If you're a federal contractor, this obviously applies to you. And it's very specific on what you need to do and what the requirements are. It's very specific that if you do not follow these rules, you could not only lose that contract, you could be barred for up to 5 years from any additional federal contract. So it's not one to be not paying attention to.
Right. And the same with the next slide, the DOT. They've made it very clear, the Department of Transportation has made it very clear that it doesn't matter basically what the law is in your state. Driving is a safety-sensitive position, and therefore, no drug use is tolerated. So we kind of blew through those last few slides.
In an effort to have a little bit of time for you to ask questions. And again, we do appreciate that this is a very complicated process. Our goal is really to try to give you some big picture thoughts on how to manage this. What it comes down to is hopefully our message throughout all of this has been, one, do the analysis, do the assessment of what's going on in your state. And of course with the federal laws and what exactly you must be ensuring that you're following in your particular state and or states. I realize that many of us have multiple locations across many different states with many different laws, which makes it more challenging to write those policies, but they can be done. So we have done those. It is doable. So you also then, of course, comes back to the policies, communication, and training. And if you stay with that, most of the times it's going to keep you hopefully as safe as possible.
As risk-free
as possible. But of course, as you all know, favorite HR answer, you could all be saying it right now. What's the favorite HR answer to any situation? It depends, right? It depends on the situation and all the specifics that are related to it as far as the decision that we have. We certainly appreciate your time being with us today. I know Lila has been hopefully gathering some questions that we'll either answer now and or we will respond to you online as soon as she gives us that information and allow us to do that. Thank you.
Thanks so much, Cheryl and Jim. Really appreciate it. Lots of good information here. Sometimes as like a operational HR person, a lot of the information is so over my head sometimes, but this is very helpful and very interesting. So definitely learned a lot today personally. And I did have a few questions that came in. One was, what was the name of the case in Oregon, Jen, that you were talking about earlier at the beginning of the workshop today?
Okay, he's looking that up.
I'm getting out my file.
Yes.
Okay. Cool. I will lob another question while you're looking that up. I have another one for you. Another question came in. Can I prohibit my employees from using medical marijuana?
It depends on your state.
Favorite HR answer?
If you're in Pennsylvania, Arizona, Delaware, or I don't know, what was that other state? Minnesota, I think.
I think it was Minnesota, yeah.
No. But other states, yes. And even in the states where I say no, it is back to what Cheryl said. It depends. It depends on, what your workplace is like. If they're safety-sensitive positions, maybe. Even in those states where there's caveats to protect the employee who uses medical marijuana, there's ways to deny it if it's safety-sensitive positions or there may be other caveats in that particular law. By the way, I have the site for that case. It's called Emerald Steel Fabricators, Inc. versus Bureau of Labor and Industry, 348 Oregon 159, and it's a 2010 case.
Okay, thank you.
And on that prohibiting medical marijuana, again, favorite HR answer, as Jim was saying too, we both are repeating that, but it's also back to some of those federal laws too. He mentioned the safety sensitive positions. If you're a federal contractor, yes, all right, because there's a zero tolerance policy for any type of drug that's on the schedule for the Drug-Free Workplace Act and the Controlled Substances Act. So in those cases, absolutely. In states that don't have it there, you're a little bit more on, got some wiggle room there. And then there's the total philosophical question is, if medical marijuana is helping someone to be able to treat with a condition and it's proven that it can help, there's a decision that you're going to have to make too from that perspective. It's not an easy answer.
I'm guessing that the person asking it wants an easy answer. They want a black and white answer, and a lot of employers do. That's what we prefer, is to know we can be safe doing something. This is an area where, at least for a period of time, it's not going to be that easy. Honestly, a lot of this could be cleared up if the federal government just removed marijuana from the Schedule II and Controlled Substances Act, which they could do. Legislation could do that. A lot of these issues would go away. Then it would just be strictly states' rights. It would no longer be the federal issue, and you just would look at your state law. But until that happens, it's going to be murky.
Okay, I got one more question for you guys that we could probably squeeze in here. So someone has this question. So they have a employee who was issued a medical marijuana card for pain, and they're recently found out that they were using medical marijuana during their lunch breaks. Is this something that they can fire him for?
Yes, so let me preface this by saying I'm not that person's attorney, and this can't be construed as legal advice. It's just a general legal information. That's my disclaimer. But more than likely, yes, they could fire them for that, because most states, even those states that have medical marijuana, do not allow for impairment on the job. So they wouldn't allow a person to take marijuana while they're working. Now, where that is going to be tested is in intermittent FMLA with issues like migraine headaches or things that require, an hour or two absence from work at a time. And if that's what they're treating with, I can imagine at some point that's going to be tested. I haven't found any cases where it's been tested yet. But in general, probably they can, but they should talk to their attorney.
And that's that FMLA piece too, so that's obviously going to tie in very closely as to how that particular situation is being managed. And so obviously we need quite a few more specifics to be able to give the ideal answer, but hopefully that's enough information to recognize that you have to go back and get all the specific facts and how that applies to you in your state with your laws and with FMLA.
Awesome. And I wanted to squeeze in one more, but we're running right up on time, and in case anyone else has any other meetings don't want to go over. But I really appreciate you guys joining and helping everybody today and answering questions. I'll send any of the other questions over to Cheryl and Jim directly so they can reach out to you. And their contact information is in here. We will be sending out all of these slides to everybody, so you'll have a resource for this. So definitely keep your eyes peeled. We're also going to be releasing a little bit more comprehensive resource on this later. So kind of if you already are subscribed to our emails, definitely stay subscribed. And if you aren't already subscribed and you want to opt in, just send us a note and we'll be happy to make sure you receive those. So you kind of, as we develop more resources, you'll have them. So thanks again, everyone. Thanks again to Jim and Cheryl. Really, really appreciate it, and looking forward to seeing everybody on the next workshop.
Thank you.
Thank you. Please